Hello, welcome back to this channel. So today is our uh, third class, third chapter regarding current affairs. And in today's topic, we have some important. In today's class, we have some important topics to discuss, including National Capital Territory of Delhi Amendment Ordinance 2023. Then we will discuss after that Model Prison Act, and we will discuss few small articles. So let us let me tell you one thing, that all these uh, things what we are discussing here had happened almost 5 to 7 months ago. So there were many changes which we would discuss when we will reach to them, and everything will be clear after I complete this. After I complete all these classes. And secondly, as always, medium would be in English, and where I won't be able to express myself, I would use Hindi there. So let's jump to the topic. It is about National Capital Territory of Delhi Amendment Ordinance 2023. So why is it in news? Why was it in news then? Actually, central government, which issued the Government of National Capital Territory of Delhi Amendment Ordinance 2023, it seeks to amend nctd Act 1991. This act was brought up by 69th Amendment Act of the Constitution. So before going to the history of this, before going to discuss this uh, topic, we should know a little bit about the history of the NCR, or National Capital Territory of Delhi. You know, always from the beginning they did not had the legislative assembly, so it was first governed directly by the president through its administrator. Then amendment was brought in which it was given legislative assembly. Then again it was taken off. Then in 1991, by the 69th Amendment Act, this legislative assembly was brought again, and uh, it was, and Article 239 a, in these articles it was mentioned how it would be governed, and uh, who would be the administrator, what laws would be administered, what are the things which would be administered by the elected members, and what would be administered by the governor. So let us see what we have to discuss in this PPT. Let us start. So before coming to this discussion, why Supreme Court gave this ordinance? Why Parliament gave this ordinance? It has something to do with the Supreme Court verdict in 2023. While quoting the Article 239 AA, SC ruled that Supreme Court ruled that elected government of the National Capital Territory of Delhi has legislative and executive powers over services under entry 41, list 2 of the 7th schedule. So this was very broad verdict from the Supreme Court. It read the article itself, what was given in the Constitution. It gave it, and it further said that Lieutenant Governor is bound by the aid and advice of the Council of Ministers of National Capital Territory of Delhi in relation to matters with the legislative scope of nctd, National Capital of Delhi. I would use directly Delhi because it is very hard for me to complete whole whole you know whole name of it. So what this was, why, what made the what made the parliament to give this ordinance. So what is the catch in this? Actually, it was the part service part, and in service part that the that the power of the legislature on the subjects of which comes under state list services, which include matters related to appointment and transfer of employees of the Delhi government and the vigilance. This was the main part, which was very much, critical. It was very much to be discussed, and it was very important for the parliament to have control over it. So they gave this ordinance. Let us see what are the highlights of this ordinance. This ordinance nullifies the effect of Supreme Court decision. Now here comes the question: can Parliament do so? Yes, Parliament have extraordinary powers. It can do so. It can nullify the Supreme Court decision. It can do it. It nullified the 2023 verdict of the Supreme Court. It further explained about the powers of the legislature over services. It specified that the Delhi Legislative Assembly will not have the power to legislate on the subject of services which comes under the state list. That Delhi government, Delhi Legislative Assembly, it will not have power over the subject of services which come under the state list, as in 7th schedule we discussed earlier it. So what defines the services there? Services, what are included in it? So let us see what are included in it. Services including matters related to appointment and transfer of employees, as I already mentioned it, of the Delhi government and the vigilance. And also it brought out National Capital Civil Services Authority. It creates a new statutory body. It created it to make recommendations to the Lieutenant Governor regarding transfer, positioning, posting, vigilance, and other incidental matters. These would recommend this National Capital Civil Service Authority. They will recommend it to the Lieutenant Governor. So, what would be the composition of the National Capital Civil Service Authority NCCSA? It will consist of Chief Minister of Delhi, who will be the chairperson of the authority. Then it would also consist of Chief Secretary and Principal Secretary of Home Department. All matters required to be decided by NCCA shall be decided by majority of votes of the members present and voting. A majority of the votes will prevail. Whatever the decision they would make, there would be voting, and about the decision, majority of the votes would prevail. And one more important thing, these principal secretary and chief secretary, it would be appointed by whom? It would be appointed by the central government. So what central government is trying to do? It is trying to control this part of this services part of Delhi NCT, National Capital Territory of Delhi. So it is trying to control it. It is trying to administer it. So regarding that, they brought this ordinance. So this ordinance further explained the powers of the Lieutenant Governor regarding this matter, regarding the services matter. Let us see what powers are vested in him regarding this issue. As he will act as in his sole discretion in it. It expands the discretionary role of the Lieutenant Governor by giving him powers to approve the recommendation of the authority. He can either approve it, he can reject it. It is whole in the discretion of LG, and also his decision will be final in case of if differences arise between the Lieutenant Governor and this National Capital Civil Service Authority. Then the decision of the Lieutenant Governor would be final. So these are the few highlights of this ordinance. Let's recap it what we learned in it. It nullifies the effect of Supreme Court decision which was given in 2023. It defined the powers of the legislature over services which it nullified. It brought up National Capital Civil Service Authority, which would be recommending to the Lieutenant Governor. It would have Chief Minister as it is chairman. It will have a principal secretary, and it will have chief secretary. And also majority of the, if any decision is there, they will vote for that decision and majority wins. And these chief secretary and principal secretary, they would be appointed by whom? They would be appointed by the central government. And also if the differences arise between lieutenant governor and this National Capital Civil Service Authority, then the decision of the lieutenant governor will prevail. So it is in the discretion of the lieutenant governor. So now let us have a little discussion about ordinance making power of president and governor. So what is the history of the ordinance? Power to promulgate the ordinance is vested in the Indian Council Act 1861, Government of India Act 1909 and 1935. In these acts, this ordinance was mentioned. Power to promulgate the ordinance was already vested there. And in Article 123 for President can issue ordinance. Power of President to promulgate ordinance during recess of the Parliament, and for Governor it is 213. You know, these ordinances which President or Governor issues, they are most likely to be temporary. Why? Because when the Legislative Assembly comes back, it is their decision within 6 weeks from the date when the next session starts. It is their decision to hold it, to have it, or to hold it, to end it. And this ordinance may lapse earlier also if the president or the governor withholds it, or if both houses pass resolution to disapprove it. And also one more thing, it can be issued on matters on which parliament or legislature can make laws. It is very important for that, or this is the most important point in it, that the ordinances can only be issued on matters. I am again reading it. Ordinances can only be issued on matters on which parliament or legislature can make laws, and are subject to some limitations as parliament legislature to make laws. Further, we will see. Further, governor has few other limitations. Mostly, if we will club them, it would come under one. If any law where prior recommendation of, when the legislative assemblies are there and the prior recommendation for any bill is required from the prior recommendation of the president, if that has to happen, then governor cannot directly promulgate the ordinance. In that is the restriction for the governor. Bills that have similar provisions require the prior approval of president, and if an act of state legislature containing same provisions would have been invalid, then governor cannot promulgate the ordinance. So this was about National Capital Territory of Delhi Amendment Ordinance and 2023, and how it reacted with, how it acted with, how they subdued the Supreme Court verdict, and they how Parliament diluted their verdict. Now let us have little discussion about Article 239 AA. It was, as I already mentioned, it was inserted by 69th Amendment Act 1991, which conferred special status on Delhi. On whose recommendation, it is very important, S. Balakrishnan committee, they recommended it. What it provide the NCT of Delhi will have an administrator and a legislative assembly. Second, legislative assembly shall have power to make laws with respect to any of matters in state list or concurrent list except subjects of police, public order and land. In case of difference of opinion between LG and his ministers, Lieutenant Governor shall refer it to the President. These are the few important tidbits, I would say, few important provisions of this article which we have to know. Article 239 AA, brought under 69th Amendment Act, provided Delhi will have administrative and legislative assembly. The legislative assembly will have power to make laws on the matters on the in the state list or concurrent list except what are the exceptions: police, public order and land. And in case of difference of opinion, lieutenant governor has to refer the bill to the president. So this is about NCT of Delhi. Now let's move to our next topic. It is about Model Prison Act 2023. So as usual, we will discuss why it was in news. Ministry of Home Affairs has prepared the Model Prison Act 2023 that will replace the Prisoners Act of 1894. But I have a question here for all of us that prisoners do come in the state list. So can uh, so who has the power to amend the prison laws? It is definitely state. What central government is trying, they would give the model how prisoners should work, and it would be the guiding thing for the state governments, and they would regulate the laws according to that model. So let us discuss first. We would discuss about Prison Act of 1894. This is very important act as it was the first act which legislated and governed the administration and governed and administered the prisons in India. Let us see what it had. Uh, the act has its origins in the recommendation of the Prison Discipline Committee appointed in 1836 by Lord Macaulay. It may be asked in the prelims about, as this was in the news, prisoners are in the news, and this question from the history, it may be asked how, current affairs, they connect these things in different ways. This may be asked in question in prelims. Origins for recommendation of the Prison Discipline Committee 1936 by Lord Macaulay. How Prison Act of 1894, which recommendation brought it, it might be asked. So we should know that it was the Lord Macaulay Commission, Prison Discipline Committee 1936, brought by Lord Macaulay. What it did, it defined the prison. How it defined it? It defined a prison as any jail or place used permanently or temporarily for the detention of prisoners, excluding police custody and subsidiary jails. It also laid provisions for the prisoners' employment, health, and visits. That how they would work there, how they would reform them, how they would take care of their health, and how visitors would meet them. It gave all the provisions regarding that. But Ministry of Home Affairs found various shortcomings in the act and noticed a significant lack of emphasis on corrective measures. They thought that it should be corrected. There are many lackings in this act. It is way colonial in nature, and it degrades the prisoners, and the condition of the jail is very different and the number of under trials, if we will see in India, they are huge, and the capacity of the jails is very less. So there is a need for the reforming of the jails, reforming of the prisons. Let us see what we have, what constitution says about prisons. As I already mentioned, as per the provisions of the constitution, prisoners and persons detained therein fall under the state list, which means responsibility of prison management and administration solely rests with the state government. Thus, what would happen? This model act may serve as a guiding document for the states so that they may benefit from its adoption in their jurisdiction, as I already discussed this. Now, what Ministry of Home Affairs direct the Bureau of Police Research and Development to review the law and prepare a new draft which culminate in the Model Act 2023, whom they directed Bureau of Police Research and Development, BPR and D. This is important. So what is the need for the reforming the act? As I already mentioned, colonial hangover, what was there, India's incarceration system is prone to abuse since it was set up by the British to subjugate political prisoners. The act permitted whipping provided the number of stripes shall not exceed 30. That was very cruel, to make prisons reformative institutions rather than disciplining them. You know, current situation of this act majorly focuses on the disciplining. Let us see Prison Act 1894. It focused on keeping criminals in custody and enforcing discipline and order in prison, leaving no provision for reform. There was no provision for reform, rehabilitation of prisoners. So it is needed to reform this act. Then, for better living facilities of prisoners, if we would see the facilities of the prisoners, if we will see this act, it is very worse. It is very disgusting for the prisoners, and they are also humans. We have to understand that maybe they had committed some crime, but we have to have humane conditions for them. And one more thing, killing and violence within the prisoners, there that is very huge. As I can remember in 2000, recently one gang member was killed, and I can remember there was a prisoner who belonged to Pakistan and he was killed here in so there are many killings happening in prisons, and there are high under trials. Prison statistics of India 2020 show 21. Prison statistics of India 2020 show that more than 77% of jail inmates are under trials, and high, which leads to high occupancy rate of prisons, which further leads to difficulty in obtaining bail. So this bail provision, it is very much needed, as recently it is present news that Supreme Court CJ of Supreme Court said that CJ of India said that these lower courts, they refuse to bail, as bail it should be very much common, and refusing bail should be an example. It should be an example. It should be very way, मतलब कि जो bail, if you have to bail anybody, it should be very common. It should be given easily rather than withholding the bail. But what is happening in lower courts, they are withholding of bail is very easy there, and it is prevailing there. But giving a bail, we will see that in very rare cases. What CJ said, bail should be easily available. And out of an example where the crime is very serious, there we can withhold the bail. But situation here is very different, and We have, because of that, we have high under trials. We have high occupancy rate of prisons, vacancy in prison office officials. That is also one of the big concerns here, as Uttarakhand, Chhattisgarh, Bihar, and Jharkhand, over 60% of officer positions were vacant. So that's very grave thing to have. And unnatural deaths in prison, it is very common in India also. So there is a need to reform this act, and it is very much in demand for the present time, that our jails, our prisoners should be very much sophisticated. They should be the rehabilitated centers rather than you know punishing them. They should rehabilitate. Our aim should be rehabilitate the criminal rather than making their life more miserable. So let us see what are the proposals included in the model act. First, to encourage good conduct and provisions for the grant of parole, furlough, and remission to prisoner. So let's see what parole is. It is a system of conditional release of a prisoner and suspension of the sentence for a specific period of time. And for furlough, it is given in case of long term imprisonment. The period of furlough granted to a prisoner is treated as remission, reduction of his sentence. And bail means procurement of release from prison of a person awaiting trial or in appeal. For if anybody is given bail, it doesn't mean that he is not a criminal, but until crime is proven, everybody is innocent. Until proven, you are innocent. So bail is issued there where these inmates are under trials and their guilt is not proven. So till then, CJI recommend that bail should be given. They should be uh, they should be given right to live till they are proven guilty or they are proven innocent. And what are other provisions for reformation and rehabilitation? As I already discussed it, for better safety and security of the prisoner, it is very important. There should be separate cells for transgenders, for men, as as different things are happening right now. Different situation by time, everything is evolving. So there should be these things should be put under consideration, and there should be separate cells. It should be well sorted out. So it is my personal view that these prisoners should be sorted out. That prisoners which are sharing the barracks, they should be sorted according to the level of the crimes and according to the personality of the prisoner, according to the personality of the criminal. There should be a good psychiatrist should be involved with them, who would discuss, who will study the psychology of the criminal, and according to it should be well managed system. So by this we can reform it in a better way. This is my view over this is my personal view. You can have differences over it, but if you like it, you can take it. But what is mentioned in these slides, that is totally valid, and there is no zero doubt about that. And I would mention it again, if you don't like the way I am discussing it, you can mute this, but please go through these slides, read them. It would be very useful for you to in uh, it would be very useful for you in cracking the exam. Because you know what happens usually, when you would see the papers, questions would revolve around the topics which are in news. So what I consult different magazines, and I take the gist of those magazines and I post it here. So I hope you would like it and you will appreciate it. and you will subscribe to my channel, so I would grow up. Still now I did not got any views in my last two videos. Let us see how long it would take anybody to watch my video. And let's move to our next topic. It is about the whip. So let us see why it is in news. As our rule, we see why it is in news. Constitution bench in Shiv Sena case ruled that power to appoint a whip and a leader rests with the political party and not the legislative party, as stated in 10th schedule of the Constitution. So let's define whip. What is it? What is whip? Let's have a little discussion over it. A whip may refer to both a written order to members of a party in the House to abide by a certain direction, and to a designated official of the party who is authorized to issue such a direction. It may be a written order, or it may be the man, it may be the official who designates the members of the party to function certainly. And one more thing, all parties can issue whips to their members. Parties appoint a senior member from among their house to issue whips. This member is called as a chief whip, and he is assisted by additional whips. The senior most member appointed by the party who gives these directions is called the chief whip, and he is assisted by the other whips. So here comes the question of disqualification under 10th schedule. So if any member does not abide by the whip, or by the whip given by the political party, he might get disqualified regarding that. Let us see what Supreme Court sorry, this was about whip. And so I think this is Florida is there is MLAs have the right to participate in proceedings of the House regardless of pendency of any petition for disqualification. And also floor test, and there is one more important thing which I have discussed regarding the disqualification. It is the speaker who decides who will get disqualified. How who to decide disqualification? Disqualification ought to be decided as per established procedures in law, and the speaker is the appropriate authority for this under the 10th schedule of the Constitution, which lays down the anti-defection law. Emphasizes that the speaker should decide on pending disqualification petitions in reasonable time frame. There is a time frame given to the speaker where he decides whether anybody has been disqualified or it is allowed under the law. So regarding whips, I think this was the end enough to discuss. It is a very small topic here. It is the part of the 10th schedule, and this might come in exam. What are whips? What is chief whip? So this what we have to learn about it. And if any party member does not follow the whip, his fate would be the disqualification. Now now let's move to the next article. It is about recusal by judges. What is recusal? Let us see why it was in news. Supreme Court judge refused to recuse himself from hearing a plea by a former IPS officer to prevent the perception of being biased. So there was a case, and IPS officer has plead against the Supreme Court judge. So this case came to this particular Supreme Court judge, and what he did, he recused himself. It is in the discretion of the judge itself. There is no particular law regarding the recusal. So he thinks that it would feel biased if he will listen his own case. So for that he recused himself. He did not heard it by himself. So now CJ will decide another judge for him. So this is what you have to learn about the recusal. It might be asked in the question. This term recusal was in the news. It is regarding what, and there might be many options, and one of the option would be it is in the discretion of the judge to hear his case again, to hear the plea against him, to withdraw from the case by his conscience. So here we in recusal we have two important terms. One is nemo judex in sua causa. It is some difficult. What does it mean? That is, no person shall be a judge in his own case. It is not any provision, but it is usually said that no person should be judge in his own case. And one more thing, justice must not only be done but must also be seen to be done, which was propounded in 1924 in Sussex Justice by then Lord Chief Justice of England, that justice must not only be done but also seem to be done. For example, if anybody hears case against himself, and if he would be genuine and he gives his decision in favor of himself, then mostly people would say, mostly the one who the one who was playing this case, he would say that he was very much biased, even if he did the justice with the case. So that is why it is said that justice must not only be done but also seem to be done. Nemo judex in sua causa. This might also be asked in exam. This term, it is related to what? So we should know what it is related to. And let's move the kinds of recusals. It is automatic. There we have two types of recusal. One is automatic, in which judge himself decides that he won't listen his case and withdraws from the case. And second one, when a party raises a plea for recusal, highlighting the possibility of bias or personal interest of the judge in the case. These two things might, these are the two kinds of recusals which we find. Recusal, by recusal we mean judge, uh, we can in lame language, in layman's language, we can say that judge replaces himself, or we want somebody else to hear our case rather than anybody else. We feel that he has some personal interest or this plea is against him. So these are two kinds of recusals which we need to know. It is automatic and when a party raises a plea for recusal. So key observations of the Supreme Court. Sorry, I had these. This slide is from the whip. Appointment of whip speaker to decide. Sorry, this got a little bit mixed. I'm really sorry for that. So this is all about today's class. Today's sorry, I won't call it class. I would call it discussion. What are the topics which we discussed in it? First, we discussed National Capital Territory of Delhi Amendment Ordinance 2023. Let us recap it a little bit. In it, how Parliament nullified the Supreme Court verdict 2023, and how it defined the powers to legislate over services that the legislative assembly of Delhi will not have any power to legislate over the subjects of service. What service contains in it? What is included in the service? It is related to the appointment and transfer of employees. Then what was the second thing which this ordinance brought? It brought the National Capital Civil Service Authority and CCSA. What it contains? It is a statutory body and what would they will do, they will recommend it to the they would recommend to the lieutenant governor. What does what how many members are there, and uh, what it consists of? It consists of chief minister of Delhi, who will be the chairperson, and it also consists of secretary, chief secretary, and principal secretary of home department, who are decided by central government. And powers of the lieutenant governor, if there is any disagreement between the between National Capital Civil Service Authority and Lieutenant Governor, then Lieutenant Governor will prevail. Then we discussed about the ordinance making power of president and governor. It how what were the acts it was contained in, and in the constitution it is mentioned. For example, for president is article 123. Please remember that article 123, power of president to promulgate ordinance during recess of parliament, and article 213, power of governor to promulgate ordinance during recess of legislature. Then after that we discussed model prison act 2023. What how to amend the to replace the prison act of 1894. And we discussed about the prison act 1894. It was the first legislation that governed the management and administration of prisoners in India, and also what are its drawbacks, and what why we need to reform it, and also what were the recommendations given by the model prison act. And also we know that prisoners do come in this state list. And then after that we discussed about the whip appointment in the whip part. Here this slide will show us appointment of the whip. He is appointed by the speaker. Speaker must recognize the whip and leader authorized by the political party based on the party constitution after conducting an inquiry. Speaker to decide disqualification, and we defined whip in it. It may be the written order to members of a party in the house to abide by a certain direction, or a designated official of the party who is authorized to issue such a direction. And we also discussed that all parties can issue whips to their members. Parties appoint a senior member from among their house contingents to issue whips. This member is called a chief whip, and he is assisted by additional whips, he or she, whoever it may be, regarding whatever the gender would be. So the regardless, in that way we would know what would be their pronouns. So I hope you liked this. I know I was not that much fluent in explaining this, but I am improving, and I will promise you by time I would improve. But one thing I will tell you again, please do note these points. This would definitely, these questions might come in the exam, and most probably questions would revolve around them. Go at least see the topics which we discuss here. I am taking these current affairs from the beginning of 2023 till April 2024. So it would include full year current affairs for every subject. I would try, but at least I would try to complete for polity. I would try to complete for international affairs. I would definitely complete for polity. Definitely complete for international affairs. Definitely complete for economics and ecology and environment and science and tech. These 5 subjects I would definitely complete before 15th April. I would complete all these subjects. Then, if time permits, I would take up security also. which is very important. And my best wishes to you guys. Please, if you are watching this, recently I had got 0 views in my last previous uh, videos, so let's see if anybody watches this. And I would be very thankful to the person who would watch my videos. Thank you very much. Best of luck to you, and have a good journey in your exam. And I wish all of us succeed what we desire in our life. You know, let us discuss this somewhere else. I'm a good motivation speaker when it comes to speaking, and I would motivate you very well. Thank you very much. Take care.